What evidence is needed to successfully contest a will? Have you ever wondered what it takes to challenge a will? Contesting a will is not just about disagreeing with its terms. It requires solid evidence to support your case. Let's break down the types of evidence needed to successfully contest a will. First, one common reason for contesting a will is lack of testamentary capacity. This means the person who made the will, known as the testator, did not fully understand what they were doing when they signed it. To prove this, you will need medical records that show cognitive impairment or mental illness at the time the will was created. Expert testimony from medical professionals can also help confirm the testator's mental state. Additionally, witness statements from family or caregivers can provide insight into the testator's mental condition. Comparing the current will to previous versions can also reveal unexpected changes that suggest incapacity. Another ground for contesting a will is undue influence. This occurs when someone pressures the testator to change the will in a way that benefits them. Evidence for this can include testimonies that show the testator was isolated or vulnerable. If the influencer had a close relationship with the testator and gained more than what seems fair, that is also important. Documentation or witness accounts of any coercion or manipulation during the will's creation can strengthen your case. Fraud or forgery is another reason a will may be contested. If the will was created based on false information or if the signature is forged, you can challenge it. Evidence needed here includes forensic analysis of handwriting to check for forgery. Witness testimony can also help prove that the will was not executed authentically. Furthermore, if the testator was misled about what the document entailed, that can be significant evidence. Improper execution is yet another basis for contesting a will. Wills must follow specific legal requirements, such as being in writing and signed by the testator. To contest on these grounds, you need proof that the will was not properly signed or witnessed. Documentation showing that the will does not meet state-specific legal formalities can also be crucial. When considering contesting a will, gather all relevant evidence as early as possible. This includes medical records, previous wills, witness statements, and expert evaluations. The challenger must meet the burden of proof, which usually means showing that it is more likely than not that the will is invalid based on the evidence presented. Courts relying heavily on credible expert testimony and clear documentation to make their decisions. In the context of elder law and estate law, contesting a will often involves sensitive family dynamics. It is essential to have legal counsel experienced in wills and trusts to navigate the complex requirements of challenging a will. This ensures that the true intentions of vulnerable individuals are protected and that the integrity of the estate is maintained.